I had asked, and again, I want to express to Representative Rogers and Representative Zuber thanks for their work of their subcommittee. Is Representative Bennett still around by chance?
Yes, sir.
All right, he'll be back in a minute.
Well,
He'll be back in a minute.
I think he's around here close by.
Well, tell him to come in.
Okay.
Yeah.
He's on the phone. I told you.
Oh, he's coming in here. Okay, that's fine. Well, I have also asked Representatives Cockerham and Rogers and Hines as a subcommittee of 3 to look at really employment. What do we call it? Employment setting, employment, workplace sort of issues, which would include certainly not be a workplace environment. Certainly would include, but not be limited to, a sexual harassment policy, that sort of thing. And so we're going to start with Representative Cockerham. He can give that report on that committee. I see we have the Speaker come in. Let me just give you a quick update, Mr. Speaker, just in case you're interested. This committee has met since beginning 1 o'clock. We took a brief recess. We have, you were here, of course, in the meeting this morning, but we have had an extensive report from over an hour from Representative Zuber, Turner, and Perkins about the space availability within the Capitol. And well, it was very well. It was very. It was very informative, and the good news is
Not that something. Well, I'm sorry. But
that's all right. I was going to say the good news is the good news is that we really do believe that we're really close to having appropriate office space for all our members, at least a place to sit. Obviously, a lot of the junior people are going to be up here on this level sharing the spaces, but there's a lot of space available, and we tentatively have authorized the subcommittee to come forward with a final recommendation for us to take action on the middle of next week, which will give them the flexibility to recommend where this space needs to come from. It looks as though it will not be necessary for us to, although we did consider it and certainly could continue to consider it, does not look to be necessary to do anything with the press area because we're going to have sufficient space otherwise. Probably would also, although there may be some relocation, there's probably not going to be a need to relocate or unlocate, might be the appropriate way of saying, the LBO personnel. There was some flexibility there, but we should have enough room to do the things we needed to do. I also shared with the committee your desire to assign 2 areas, chairman spaces basically, 2 chairman area spaces to the minority, House minority, and explain your thinking there, and that we do plan to do that as part of our space assignment as well. It's our hope to have by the middle of next week the space identified and ready to be drawn, really, for seniority purposes. And also, we're going to identify the spaces for the particular chairman and vice chairman before we know who chairmen are. I mean, the idea there is to do this without any personalities involved, take a look at what space is there, how it relates to the support staff there, and the proximity to the appropriate committee meeting rooms and those sort of things. Have that ready so that whenever you name chairman or committee structures, which we're anticipating, maybe it's whenever you say, but it could be as early as sometime next week. We want to be ready for that, and I think we will be, and they've done really good work. We also have a subcommittee, I just mentioned, that Representative Cockerham, Rogers, and Hines, Workplace Environment Subcommittee, that we've asked them to look at various things, but first and foremost, a sexual harassment policy and or some training, which we're given to understand is overdue. We have a need to institute this. Has been planned at some times in the past and has not transpired for whatever reason. So without further ado, I would like to recognize Representative Cockerham for your subcommittee's report.
Thank you, Mr. Chairman. The Workplace Environment Subcommittee, comprised of Representative Hines and Representative Rogers, and working with Teresa and Gwinnetta with Legislative Services, have worked very diligently, and I want to thank all of them for their hard work. and reviewing the sexual harassment policy. And I passed around copies, hopefully everyone has one, of the policy. And the first page is a form that was adopted by the House Management Committee. If you look at the policy itself, starting on page 2 of the handout, you'll see just generally like a preamble or a policy statement that was adopted regarding sexual harassment, then a definition of sexual harassment. On the third page, the very last page of the handout, details specifically if there is a complaint, kind of the protocol. If a member or an employee feels like that they've been a victim of sexual harassment, then they have 3 options. They can notify their, employees can notify the supervisor, the clerk of the House, or the speaker. And then members can notify the speaker pro tem, or the clerk of the House. And then it goes on further to talk about how there'll be confidential investigations and the corrective action that's to be taken. And reviewing the sexual harassment policy that we currently have now, the recommendation of the subcommittee was that the policy should be a little bit more encompassing in terms of covering protected classifications. Right now, this policy specifically refers to sexual harassment. It does not, for instance, refer to race or age or anything like that. So we thought that perhaps the policy should be revised to be a little bit more broader in terms of the classifications that the policy would speak to. Also, in corresponding with that, making sure that the form, which is the very first page on the handout, would also conform to whatever the policy is. Mr. Chairman and ladies and gentlemen, the subcommittee thought very carefully about this, and I think the previous policy of the Management Committee was that these forms that you see on the first page would be signed by, all employees once they were hired, and also all of the members every year. I think that, I don't know if any of you all can remember signing the forms. I'm not asking you to answer yes or no, but I think it would be helpful if we had these forms signed, every year, just like the previous Management Committee or whatever policy was adopted by this particular committee. The chairman had also asked the subcommittee to look into training, and there has not been any sexual harassment training for several years. I think the last training that was done was by Amy Whitten a few years ago. Our subcommittee decided that we would come up with several names and present those to the Management Committee for consideration. And you should have received a packet with proposals from Amy Whitten and Evelyn Beecham. And you should also have on the last page a CV from a Mr. Timothy Lindsay from Ogletree. Late yesterday evening, the subcommittee did receive 2 more proposals from Jim Keith, who said that he would perform the training for free as a gift. I believe that he has worked with the Management Committee previously, and he said that he would be willing to do this as his contribution to the state of Mississippi in order to help the House in its endeavor to make sure that all of the members and the employees are trained as it's regarding to harassment and promoting a very positive workplace environment. The reason why I included the CV of Timothy Lindsay, that's the last page from Ogletree, because late yesterday evening, he also did say that he would perform these training sessions to the House as a gift for no charge. So we have several options the subcommittee has presented to the Management Committee for their consideration in terms of training. Representative Hines and Representative Rogers and I talked about having these trainings very quickly I'm not sure what the consensus of the management committee would be, but considering that we haven't had these trainings for a very long time, we would like to at least try to have a training session before the session ends. If we could come in on a Monday, we usually come in at 4 anyway. Maybe come in a little bit earlier before we convene on Monday to have these sessions, and then have a separate training session for the employees as well as the members. In talking to everyone who is in your packet, they told me that their schedule was pretty flexible. I know Mr. Keith said that he would even be willing, there are 122 of us, he said that he would even be willing to break us up into groups of 4. When I say us, I'm referencing the members, that he would even be willing to break us up into groups of 4 if necessary. Ms. Beecham said that her schedule was also very, very flexible, and she would be willing to come, at the will and desire of the committee if, whatever the committee decided. Another issue that the subcommittee considered was that in our employee handbook, there's just a general statement about a sexual harassment policy, but the policy itself is not completely delineated in the employee handbook. So the subcommittee thought that it would be a good recommendation to have the entire policy, whatever it is, that it really needs to go into the handbook, the entire policy. So that way, kind of like as a backup, whenever a member or an employee is signing this form, not only are they saying that they understand the attached policy, whatever it is, but, if they are reading through their handbook, it's also there clearly listed. One other issue that we also talked about is a sexual harassment coordinator. And in our discussions when we talked about this, we thought that it would be good. We thought that it would be good to have someone, if we're going to have these forms where employees are, once they're hired, if they're saying, I understand this policy, I've read it, I'm aware of it, I've done this training, there needs to be one person who's collecting these forms and confidentially, I know Representative Hines and Representative Rogers and I talked about this yesterday, making sure that these forms are not accessible to everyone, but they're contained so that, one particular person has them and that they also keep up with them. I think that's important. Hopefully there won't be any claims in the future, but if there are, then this one person, has these forms. And it's my understanding that Ms. Lisa Davis has been the sexual harassment coordinator before, and we talked about it. I think Ms. Davis she's always been very resourceful, very knowledgeable, and she does a good job, in my opinion. And we thought we would recommend and suggest to the committee that she continues because she does a very good job. One last thing, and then I'll take any questions or comments. We talked about, or the policy, the sexual harassment policy that we currently have talks about confidential investigations. And Legislative Services does a terrific job. I think heretofore the investigations have been done internally. Our subcommittee talked about perhaps having an investigator, if some particular complaint is filed, having an investigator that would come in, and that way it would remove anyone here who works here having to go and do the investigation. Just so, it wouldn't, not that there would be any impropriety, but a lot of times you may develop a relationship with particular members or something like that, and it just removes the middle person, and you have someone who is neutral coming in to do the investigations. And so we contacted Mr. Jim Keith again because it's my understanding he had worked with the management committee before, and he said that it was his recommendation that if we needed to have an investigator, that we do it on an as-needed basis. And he gave a flat fee or an hourly rate, pardon me, of $200 per hour, which is very good considering the rates of some attorneys. It's a little bit
Certainly
more.
to be very, very discreet. I mean, you want it known, well, Mr. Keith was here to see Richard Bennett. Wonder what that's about. I mean, you know, we really do need to be discreet about that sort of thing, but hopefully he would. I was being serious. I'm not.
No,
but you know
you're
what I'm
right.
saying. It's a serious issue.
Well, whoever
I
it
thought
would
about
be.
me, you answered.
Whoever it would be.
Sure. It would
Yeah.
be-
He's arrested you.
You asked him who would keep up the personnel file, just placing the personnel file every sign.
It should be in the personnel file, but I don't know about anyone else. I haven't signed one of these every year.
No, I meant the employees, not the house.
Oh, right. Oh, I'm sorry.
Just to curtail off of her statement, whoever does the training cannot be the investigator. It has to be an independent trainer and an independent investigator. So, which I like the fact that the free, but if we're going to use Jim Keith as the investigator, he can't be the trainer.
Oh, no. I agree with that suggestion. I think it needs to be separate. I was just kind of giving all of the information to the committee.
One other thing is that in this training, we as the leadership group have to be responsible to ensure if a person misses a training, say for instance somebody's out ill or sick or something like that they don't skirt tail through the cracks. So there has to be an active
They sign this form upon completion of the training, I assume.
Right.
That's when they would do it. And if they don't have a form from them, they haven't been to training.
Right.
You bird dog them down.
And the case law.
Dirty old man asked the question.
Oh, I'm
I didn't
sorry.
know that.
What was your question?
Will age give you any exemption?
I don't think so. I really don't think so. I just wanted to share with the committee. And looking at some of the case law over the years, it's changed. I mean, before, it was all sexual harassment, and now there are other classifications that are included. So in order to have a really comprehensive policy, I think it needs to be revised.
Well, that's what I was going to ask. You've covered several things. First of all, we're talking about a more or less a comprehensive harassment policy that would include, certain sexual harassment, racial harassment. I guess it was some sort of gender harassment, that sort of thing. And I don't know what other forms of harassment.
Age
Is age discrimination?
Age discrimination.
Age discrimination.
Age discrimination.
Y'all leave Ray
discriminating
alone.
against short people.
Well, there are legally recognized areas that we would want to make sure that our policy would encompass. And if I'm hearing the lady correctly, I think what she's recommending is that we rewrite or expand, certainly modernize and update our harassment policy to be more comprehensive. Is that?
That's right, Mr.
All right.
Chairman.
I would ask, now I assume this is something our subcommittee would do with the assistance of our legal staff. Is this something y'all are prepared, if this committee charges you to do, to come up with a draft comprehensive policy that the committee would adopt for the House and also include within the manual and be the basis for the training? Is that what we're talking about?
Yes, sir, that's what we're talking about.
All right. I see the gentleman here.
I had a question for you. Continue.
Oh, I'm through. I just saw you raise your hand. I just.
But I want a
She's
clarification.
sharing it. I just was butting in. Go ahead.
I have a clarification on your task,
Okay.
though. When you say working with legal counsel, are we going to be working with legislative services or someone who submitted the proposal to?
Well, that's a good point. What I was trying to, however it's easiest to do it, if we've got somebody that's going to help us with the training, did that necessarily mean they're going to help us prepare a policy? I didn't necessarily understand it that way. But it may be one and the same.
Well, we did have someone who did offer to take a look at the policy as well
Okay.
and make suggested revisions for the
Well,
committee.
certainly that would be, I think, preferable if that makes sense. And I certainly like the offer of the free work. And I don't know any of these individuals that you named, not to be honest with you, but I know Mr. Hines, Representative Hines has some expertise in this area, and I guess are y'all comfortable with any of these people that have been named? I mean, if we've got someone that's offering free services, if they're otherwise competent, and if we have this separation that we're talking about with the investigation, is that now y'all are perfectly free to make a recommendation of another individual or something if you like.
I think in the packet, I think two people agreed to help rewrite the handbook too. Did I?
Yeah.
I read it right now.
We have
My age is catching up.
actually all four of the people that we've presented for consideration by the committee, all four of them have agreed to help
All
rewrite
right.
it.
So rewriting, so that's not a separate task, really.
No, it's not.
Okay, that's good clarification. All right, then I suppose we would be wanting a motion for discussion purposes.
Discussion, question.
Yeah, all right. Well, do you want to put a motion on first before we discuss it? Go ahead.
No, question first.
Yeah.
Thank you. Madam Chairwoman, I have never litigated a sexual harassment case, but I've probably litigated every other case that you can think of. And I always tell my business clients and my individual clients, the less you put down on paper, the better off you are. Because if you put everything down on paper, and if you violate that policy, you're on the hook. How does that relate to what we're trying to do today?
Oh, let me answer first.
You're in charge. You say who is.
Yeah, let me answer first, please. I agree. I practice just as you do. So I agree that the less that you have on paper, the better. But sexual harassment and harassment claims are a little bit different. As you know, there are affirmative defenses for certain claims. And if there were to be some kind of claim that was filed, in particular, let's say, for instance, for sexual harassment, with the affirmative defense that you have for that particular claim, then number one, say, for instance, the employer, which would be, us or the house, then you would have to show that you did put forth some kind of proactive steps. And I'm not saying those steps need to be actually in the management policy itself, the harassment policy itself, but you do have to have certain programs and certain policies in place. And you don't have to say, supervisor cannot do this, or something like that. I don't know if you've seen the actual definition, for instance, of sexual harassment, if you've had an opportunity to read it, but it gives you certain examples. So it's not going to be overly specific. I mean, I'm not speaking that you set forth and delineate everything in the policy, but I do think that the employees, the staff, as well as the members ourselves, that we need to have some kind of definition or some kind of concept of what may constitute sexual harassment, because what you may think is okay, I may find offensive as a female. And I'm not trying to say that you've done anything offensive, I'm just using you generally as an example. So I wanted to just say, you haven't done anything, but I'm just using you as an example.
This policy will not cover partisan harassment. We're not going to go there.
But you understand my concern.
Oh, I understand your concern completely. You don't want everything in writing, but I think, for instance, with this particular form, I think the previous management committee I commend them in trying to have this form, because it shows that the committee, the House, was being proactive and saying, listen, we do have a policy, number one. Number two, this particular employee or this particular member has read the policy, so that if there ever was some kind of complaint that arose and there was litigation behind it, then at least there was some evidence to say, listen, these steps were in place. This complainant, whoever it was, knew that this particular policy was in place. They knew that these corrective measures were in place. They didn't take advantage of it. They didn't file a complaint. They didn't notify the speaker. They didn't notify the speaker pro tem, or if it's a staff member, they didn't go to their immediate supervisor.
What you've said too, it really goes for all the same thing what we said with the travel policy and everything else. If we have a policy, we're going to live by the policy. So it's extremely important for us to make sure the policy is what we need it to be, because we're going to live by it. And anyway. But I hear you saying there's a safe harbor or affirmative defenses that we can avail ourselves of if we do certain things. We've got to make sure at a minimum we do those things.
Exactly.
Yeah.
If I may follow up, one quick follow-up question. Is there an affirmative obligation on us referring to the employer of the House of Representatives, to train and or educate each member on sexual harassment?
Yes.
There is? Okay.
Yes, there is.
Okay. Well, I don't know. I mean, I'm just saying.
Oh, yeah, no, I was just answering your question. Yes,
Okay.
there is.
Okay.
Representative Hines.
Most of this falls under the scope of any reasonable person's judgment. So when a person makes a claim, it has to be at the standpoint of any reasonable person standard to substantiate a major claim. If Hank Zuber said something inappropriate to Teresa Tillman and Richard Bennett is witnessing it, and Richard becomes uncomfortable with what Hank Zuber said to Teresa Tillman, that is sexual harassment. That is called a hostile work environment.
And there are two types: hostile work environment, quid pro quo.
Well, and that's right.
Well,
So you have,
but that, I understand that, but that individual member could be liable. My concern here is the House. What do we?
I think I understand what you're saying. What happens is we are all, as though we're elected, we are all still employees of the House.
Sure.
So and it's a couple of things that can take place for a person to get a chance to sue. If Teresa files a complaint against you and you hadn't touched her or done something else, she and the pro tem, she reports to the pro tem, he doesn't call you in and have a conversation with you and explain what you've done and inform you that you have violated the policy, then we open a whole different set of can of worms. You know, you get one strike, the next strike you're gone.
Well,
So there has to, it has to be a course of action. If there's no course of action, then we're on the hook for everything.
yeah. Well, I understand the individual liability. I don't want to set in place. I don't want to set the House up for additional liability by a per se violation of some type of policy provision.
I'll tell you what's got my attention is looking at the current.
That's my only
Sure,
concern.
it's actually
Now,
on
you
the
do
current.
realize we're on the hook. We could be on the hook for anything that has taken place between 1999 and now because we hadn't had a policy, right?
Well, we've had a policy.
Yeah, we've had a policy.
No, if you have not been trained on the policy, you don't have a policy.
Well, we're going to correct. We're certainly going to correct the
So
situation.
you understand what I'm saying? So
Yeah.
the
What's got my attention with the policy is that it puts obligation on the speaker and the speaker pro tem and the clerk to take certain steps, which certainly is appropriate. But if we have that obligation, we're sure going to have the training. If I'm going to have that obligation, I mean, I just think that's, and I'm sure Speaker Gunn would feel the same way.
We haven't
Yeah, I
had
know
the
it's
training in
clerk.
several years. But Representative Zuber, to your comment that you just made, I think the subcommittee and working with legislative services or whoever, if the committee, so deems that, you want to revise it and if want to make a determination on who's going to be making the revision, I think you as an attorney, myself as an attorney, legislative services, Representative Hines, Representative Rogers have both extensive experience in dealing with sexual harassment. Both of them have dealt with it before. I know Representative Hines has given training. Representative Rogers has worked with a lot in one of her previous jobs. We will, take that into consideration.
I don't have, like I mentioned before, I don't have any experience with sexual harassment litigation. I've got a lot of experience with employment relations and employer-employee litigation. The less you put down in your handbook, as you know, the better off you are. Because once you put it down, you've got to follow through with it.
Okay, so is your objection just to not having the policy?
No, I'm just saying I think it's going to be, like you mentioned before, you understand my concern, and there's got to be some type of balance to what I am saying and the requirement to have a policy and the education in place. That's the only thing I'm
Hopefully,
saying.
Can I ask you a question?
hopefully the folks we would retain would have some expertise
Exactly.
to be able to guide us, give some guidance. with it.
Yeah.
Are you saying,
Representative Hines.
maybe I'm a little confused. Are you saying that, are you talking about recourse of action for someone who is charged with this, or are you saying what we put down in regards to how we handle it? Which one are you saying?
I am talking about if you put it on paper and you make it part of the policy, and if a situation arises where sexual harassment takes place, and the House has not, well, let me be a little bit more specific as it is now. If the Speaker pro tem and the Speaker has not fulfilled those obligations, they could possibly face individual liability, is what I'm saying.
That's what got my attention.
And I don't think there's any question about that.
Oh, no, I just want to make sure I was clear.
Okay.
Well, and you're certainly referring to, in the realm of employment law, we're in at-will state, as you know.